Good morning everybody. In this present video, we are going to discuss the most controversial article 200 and 201 relating to assent to bills by the governor of a state or referring them to the President of India. You may recollect there has been lot of controversy on these two articles. Governor of Tamil Nadu has referred certain bills to the President under Article 201, which were passed by the Assembly of Tamil Nadu state. The grounds of the leader of the legislative party, that is the leader of the party which has majority in the assembly, is that the bills passed by the legislative assembly must be assented to by the governor, or he should return with his comments to the assembly. We know if the bill is passed again in the state assembly and sent back to the governor for his assent, the governor has no option but to assent to that bill. Whereas when a bill is referred to the president by the governor, his article 111 does not apply. Article 200 as regards the states does not apply. The state of Tamil Nadu filed a writ petition in the Supreme Court titled as State of Tamil Nadu versus the Union of India, stating that the governor is not assenting to bills or he is not returning with or without his comments. Instead, he referred the bill to the president. The Supreme Court too, after deliberating on it for a long time, finally decided that the governor either should assent to the bill or return it to the assembly with or without his comments within 3 months. Otherwise, the bill is deemed assented to by the governor. I bring to your kind notice the very cause title itself, the state of Tamil Nadu versus Union of India, is a wrong cause title, because the state of Tamil Nadu must be represented by the governor of that state or his assigns and not by any other person. And the Union of India is represented by the President of India or his assigns. We have also seen Article 77 and 166 with regard to states, that all actions of the state government shall be taken in the name of the governor of that state. And again, you may remember Article 122 and 212. Article 122 relates to the union legislatures and 212 relates to state legislatures. The judiciary is not supposed to interfere with legislative proceedings even if they are irregular. That means passing of a bill and its assenting by the governor are essentially legislative proceedings. Governor is part of the state legislatures in terms of definition of state legislatures. As such, assenting to bills by the governor is essentially a legislative function, and as such, judiciary is not entitled to interfere with the proceedings even if they are irregular in terms of Article 212. This being the legal and constitutional position, the democratic position is such that in any democracy, there should be separation of powers between legislative and the executive. The legislative is represented by the MLAs and MLCs of that state. The executive is represented by the governor of that state, who is appointed under warrant by the President of India. President of India is the only elected executive in India without issuing a whip. Under Article 55, Clause 3, Governor derives his power being appointed by the only elected executive of this country, namely the President of India. President is elected by the Electoral College consisting of all the MLAs in India and members of both houses of the Parliament without issuing a whip. But whereas election of somebody as Chief Minister with majority in the Assembly or electing somebody as Prime Minister with majority in the Lok Sabha alone is a lopsided system, is an unconstitutional and undemocratic system. Such provisions are not there under Indian Constitution. They are contained in Pakistan Constitution, Article 91 and 130. And removal of the governments through no confidence motions is contained in Article 95 and Article 130, Clause 5 of Pakistan Constitution. Such provisions are not there under Indian Constitution. If you say that the executive is secretary to the legislative leader, he is bound to assent to all bills passed by the majority party in the legislatures, then the word of the leader of the legislative party, which has majority in the legislatures, will become law. It is not democracy at all. Indian polity, press and judiciary and intelligence of this country have failed, miserably failed, to understand the basic tenets of democracy and how was it described or defined under Indian Constitution. President of India, being the highest elected executive, elected by the MLAs and the MPs, is necessarily a politician. He belongs to a political party, he is a political leader, and he is a politician. He represents one political party. Naturally, he will be elected only by his political party or his alliances. He will have opponents who contested as presidents, and they will be supported by their parties. So, President of India is a person who is supported and elected by a political party or a coalition of political parties. The entire constitution is about his powers, duties and discretions. He has to rule this country in accordance with the constitution. He is the executive power of the union under Article 53, and governor of the state is executive power of the state under Article 154. Their executive power extends to all matters on which the legislatures have power to make law. President of India is the supreme commander of armed forces in terms of Article 53 clause 2. In articles like 364 etc., he has powers even beyond the constitution. Under Article 361, executive cannot be summoned by the judiciary, whereas the executive can remit or nullify the punishments imposed by the judiciary under Article 72 and 161. That means a sword and shield is given to the executive to rule this country. Majority has nothing to do with the ruling of the state or the union. Like in the United States of America, there the president and governors of each state do not command majority in their respective legislatures. An ideal democracy is that where the executive do not command majority in the legislatures. If they command majority, their word becomes law. They will oppress the opposition parties. They will loot the state resources. It leads to rampant corruption, oppression and monarchy. So, president belongs to one political party. His appointees, namely the governors, should belong to political party of the president, and it is an umbrella model. Central pole of the umbrella is the central government, union government, and the spokes hanging around with hinges are the state governments, and the top cover is the Constitution of India. And the people who reside safely under the umbrella are the people of India. They elect MLAs and MPs. In turn, they elect the President of India to hold that umbrella. If someone becomes a chief minister or prime minister with single seat majority in the assembly or the Lok Sabha, the governments will be fragile. If the opposition parties purchase 2 members with horse trading of legislative members, the opposition becomes the ruling party, and the ruling party becomes the opposition party. See, after 1 month, again the opposition party purchases 3 members from the ruling party, and again the tables are turned. This is like a musical chair, a child's play, and it is neither politics, nor democracy, nor constitutional. So, when a bill is passed, how a bill is passed, we have learnt in Article 196 to 199. A bill is deemed passed only if it is passed by both houses of the state legislatures, in case it is a non-money bill. If it is a money bill, it has to be passed by the legislative assembly alone. That is sufficient. A bill having been passed by the state legislatures will come to the governor for his assent. He may either assent to the bill, or withhold the bill, or return the bill with or without his comments, or refer it to the President of India for his opinion. We know under Article 161, the governor is entitled to seek the opinion and guidance of the President of India when there is ambiguity, when he is not able to decide. He has to reserve the bill for the consideration of the President. So the Tamil Nadu governor did the right thing, whereas Indians miserably failed to understand the basic tenets of democracy and how it was propounded in Indian Constitution. There are two political forces, the legislative and the executive. Both are politicians only. So the official party is represented by the president, union ministers, the governors and state ministers, while the opposition party is represented by other parties obtaining in the legislatures, be it union legislatures or the state legislatures. If a bill is not assented to by the governor or the president, the option for the legislative majority parties is to go to the masses and explain them that they have introduced a very beautiful bill for the welfare of the people and development of the nation, but the executive is standing a stumbling block for the proposed reform by them. On the contrary, the president along with his ministers and the governor along with his state ministers should go to masses and explain why they have withheld the bill. So the passing of the bill is the stand of the legislative parties which have majority in the legislatures, and its withholding is the stand of the ruling party represented by the president or the governor. Ultimately, it is the people who should decide whether the legislatures are right or the executive is right. These two represent two political parties or two political coalitions. It is the people who will decide it and vote accordingly in the ensuing general elections. That is the beauty of democracy. Without understanding this, the judiciary is interfering with legislative and executive proceedings and even the democratic process. Power of the people to judge the legislative and the executive wings is taken away. We have to leave the people alone. They will decide the fate of the rulers. They will decide who should rule this country and who should not. I hope I have clarified a complicated issue. I request you to please subscribe, share and comment on my videos, and I will be glad to reply to your worthy comments. I have started this web series to bring to the notice of the listeners the entire constitution, highlighting wherever it was misused, misunderstood or misapplied, as a result of which the country is suffering political instability, political uncertainty, political immorality, social strife and poverty. It is time for the Indian polity, president, judiciary and intelligentsia to understand the basic tenets of democracy and how it was proposed in the constitution. I hope with your support this message will reach to as many people as possible, with fond hope that this will lead to social, political, economic reform in India for the good of the country. Thank you once again.